diligence and looking at the company. They got 125 employees in the United States, but they've got 650 of their employees are in the Ukraine, which has special issues, right? Offshore, Eastern Europe, all sorts of special stuff. And the remainder of the employees are in places like Colombia and Bulgaria and England. And so today's call was really trying to dig in and help my client figure out a way to give them what they need, but not spend all their time doing anything, nothing but just giving them documents all the time. So we had this negotiating call to try to figure out, you just gave us a 50-page list of things you want, literally it was 50 pages, and trying to call back and try to figure out what are the important things that you really need to see in order to kind of clear the company to pay this money and buy the company. So it's stuff like that. I've had a call this afternoon about helping a pretty famous milk brand in California, organic milk brand. It's doing an equity offering, selling stock to raise some money to improve their premises. So it's everything from starting the company, getting their financing, helping with employment issues, helping them grow, buy and sell a company and stuff like that. So I hope that kind of tells you a little bit of the flavor about it. One of the things I love doing though is helping start companies and working with entrepreneurs like you guys. And we do it throughout California. We're an all California firm. We have 5 offices throughout California, and then we have a couple of stealth people like in Orange County and San Diego that we're not telling anybody about that. So, and while we're focused on California, the fact is, right from the get-go, all business is international now. Everybody's positioning to do work around the world. So even though we have our offices are focused in California, we have affiliates that we do work with all over the world. And in fact, this morning, I think as I mentioned, because of this one deal, I was talking to our affiliate in London about helping my client that has a UK subsidiary and trying to figure out, okay, what do they need in the UK? Not too much, not too little. What does that look like? And trying to help the client navigate with that. So that's just a little bit about me. I'm super glad you're here. We've actually worked with Founders Institute previously in Northern California, first in San Francisco. We've been working with the San Francisco cohort for, I want to say it's been like 5 years now. And then the Oakland cohort, which is pretty new, we've been doing for the last year or so. And that's been super interesting. San Francisco, Oakland, a little different flavor culturally. My first foray into working with the LA cohort, so I'm super excited to be with you guys and see what you're doing. And so with that, any questions before I kind of launch in? Anything you guys want to focus on particularly? Or should we just kind of go through it and you can stop me if you have questions? Yeah? All right. So you guys have all these great ideas, and then the question is, well, when do you need to incorporate? So we're going to talk a little bit about sort of startup law 101. And so, you've been creating intellectual property, you've been creating business plans, you've been working with mentors, and then the question is, when should I hit the button? And particularly because it costs money to start these things. It also costs money to maintain a corporation. So when should you start thinking about when to incorporate a company? This is kind of a list we have that I think helps. There are ways maybe to delay it, but the fact is if you're working with Founders Institute, once you get your idea nailed down and you're doing these kinds of things, it's probably time to incorporate. So if you're pitching to investors, you've created IP, you're thinking about opening an office, you're going to give option grants, you have a product or service launching, you're going to enter into a contract, and so forth. Then you have to think about incorporating a company, and which pretty much when you're starting, right? How about what other special situations might require some consideration when you're starting a company? If the founder is an employee of another company right now, that's something to think about. We'll talk a little bit more about that, but when you're winding your way off of being a current employee, you've got to think about what their policies and practices are, whether you're taking any intellectual property, whether they're going to object to what you're doing, whether you have a contract, a trade secret contract or something of that effect that could affect your current company that you're trying to do. If the founder is not a U.S. citizen or a permanent resident, there's special visa considerations to starting companies in the United States. If you've already started a company previously, an S Corp or an LLC, or maybe even a non-Delaware corporation, I'll focus on that in a minute about why do I say Delaware, then that's something to think about. If you're trying to use that vehicle, then that's something to think about a little bit more, because basically you'll want pretty much uniformly use a Delaware, what we call a Delaware C corporation. We'll talk more about that later. If most of your business is not in the US, then we need to figure out what to do with that. I represent companies that come in from offshore, but the reality is because most investors in the United States are pretty parochial, they really tend to not invest out of the United States. It's a general, I mean, there's caveats for that, but the reality is when you've got IP or other things offshore, you want to figure out a way to make them domestic, and then the investment comes into those domestic entities. Or if you have pre-incorporation agreements, maybe you've got some founders or other people you've worked with before, maybe you work with your roommate in college or something like that, and you've got some agreement, you've got to kind of think about those things to see who really owns, who's going to make a claim on your company. So these are all special considerations before you hit the button and actually start the corporation to do some planning. So we talked a minute ago about what if you're currently employed. And if you are, then you ought to look at some documents that you might have signed, either your offer letter, you might have signed an inventions assignment agreement or confidentiality agreement, inventions assignment agreement. There might be a conflict of interest policy. There could be other employee documents. I don't see the lady here who I think I met at the mixer at the beginning, but maybe she dropped out, but she was asking me at the mixer, well, yeah, I'm currently employed by this healthcare company, but I'm kind of working on something that's kind of similar.
It was Amgen. She was working on virtual clinical.
That's it, right. And we were talking about her, and I was like, okay, are they gonna say that while what you're doing for them is really owned by them? In California, there's a presumption, even if you don't sign these agreements, if you're working for a company, there's a presumption that everything you're creating and the actual intellectual property belongs to your employer if it's based in their business and on their time and dime. So you kind of got to think about that, right? And so we were talking, well, what do I do? And I said, I think you really have to go back if you think that there's an overlap and say to them and try to get in writing, this is not an area I'm really interested in, and try to get them to sign off. Because I've seen entrepreneurs that go into it and then all of a sudden they get into trouble and then the company makes a claim on the IP, and that's the last thing you want to do right after you put your time, hard-earned time and money in it. So important to look at these kind of things to see, what kind of claim your current company could make on you. Yeah.
Sorry, does this also affect like your co-founder?
Oh yeah.
Because
if your co-founder's going to put some IP into the company and own something for sure, they should be looking at what obligations they have to the company they're currently employed by. And if it's in the same business, you want to be very careful. Yeah. Yeah. Now there's a labor code section in California called 2870, and it basically says, and this is the great thing about California. In other states, actually, you guys all live in California, right? So, right, okay, I'm just flying for this. California is a unique state, and it drives lawyers outside of the state crazy. Whenever lawyers I'm dealing with outside of California come into California, let's see. Let me see if I can get you another seat.
Okay. Just want to sit with that.
Yeah.
Here,
Okay.
Here, I'll sit right here. Sit right here. Sit here.
Yeah. Joseph's gonna get you another chair. Yeah. Oh no, you don't have to stand up.
You win.
Okay, good. So it drives non-California lawyers crazy when they come into California because generally in other states you can restrict employees' activities and competition in ways in California doesn't allow. And the non-California lawyers always say to me, but you protect the employer and why can't you do that? And I say, look at the vibrancy of the California economy. The reason why California is so successful, we make so many jobs because really smart people like you will come here. And they know that they can create companies. And they know that there's a limit on what the current employer can stop them from doing. But there's still complications and you need to look at these documents. But basically, if you're not working on your employer's time and dime, basically and it's not a conflict of interest with their business, you can still do things by building them in your garage, like the Steve Jobs model, right? And sort of do things and create your own company. So it's a great state to create in, but it's important to focus on these kinds of contractual obligations that might get you into trouble before you start your business.
Can I just say, actually, I've gone through this. Like since 2007, I had to, before I was employed, get them to sign off on exactly what.
Yeah.
So that was really important.
Yeah, very important. It stops trouble later. You don't
And
want to get
then
fired.
I had a company who wanted to basically steal the stuff from me. But it was written out so well, the lawyer done such a good job that they were like, yeah, no, there's no way we can do that. So yeah, it's important.
Yeah, very important, particularly on the IP side, right?
Right.
So a lot of people say, well, gee, I've heard about this thing, the limited liability company, LLCs. Why don't I incorporate it as an LLC? Because it's actually a really easy form to use. And I do a lot of work with limited liability companies. But if you're, I think for who you guys are, basically, you don't want to do it because limited liability companies are really for small businesses generally. Venture capital investors are not interested in investing in limited liability companies because they're pass-through entities tax-wise. They're not tax efficient for venture capital investors. So you also probably are going to be issuing stock options to employees, so you don't, to give them an incentive to work and create the IP and to scale the business. Stock options are very hard to issue through a limited liability company. Actually, we took a company public that was an LLC, and we had to do a huge conversion. It was a complete nightmare, hundreds of thousands of dollars eventually that really could have been avoided if they had started out with the right form, and they didn't come to us too late. So stock options hard to grant, complicated to mimic typical preferred stock rights for your investors. You guys will be the founder stock. You'll have what's called common stock rights. We'll talk a little bit more about that later. But when your investors come in, they're not managing the business, they're not intimately involved, they're just looking for a return. They get better rights than you, okay? And we might have a class on that at another time, but basically they're getting preferred rights. They'll look for return on investment before you get your money out. They'll look for investor rights and things like that. So you can't do preferreds. It's hard to do preferred kind of stock in a limited liability company. Attorney's fees are going to be higher. So don't do that. Lastly, there's something I want to talk about S corps, which is it's a corporation just like any other corporation. The C corp I talked about earlier. By the way, these letters, they're based on the tax code. So it's the subchapter C, which talks about how a corporation is taxed. With the Trump tax bill, the taxes on these C corporations have gone down to 21%. They've gone way down. If you're a small business only owned by individuals, you can elect to be taxed in another way, called an S corp, which means there is no corporate tax at all. There's some nuances to this. As long as it's just you and your founders, and you get some revenue in, and you don't have other outside investors, but you think you're going to get some money in the door, it's not a bad idea to think about electing to be taxed as an S corp, because you won't pay even the 21%. There's some nuances to this, but the minute you get investors, you can't do it because for lots of reasons. But these days they're more even than they used to be. Though there's not really a huge differential. But if you're working with a lawyer and you're trying to figure out sort of what to do with taxes, and you think you have revenue coming in before you get outside investors, not a bad idea to think about electing this S corp status. Okay. And again, stop me if you have questions as we go along.
I have a question.
Yeah.
I heard something about a B Corp. How does that fit into here?
Yeah, I have a slide on that later, but I'll just tell you now. So the B Corp, or the Benefit Corporation, is a new corporation that's now in 34 states and Delaware, and also in some foreign countries. Actually, I wrote the law in California and chaired the legal working group that wrote the law. And why did we form this new kind of corporation? Under Delaware law, you have a duty of your director to maximize shareholder wealth to the exclusion of everything else. If you have a mission-related for-profit company, and some of those companies you might think about, and I don't mean give it away or not make money. I'm talking about the Ben & Jerry's of the world, the Patagonias of the world, the Strauss Creameries of the world, Plum Organics, those kinds of companies that are premium brands, but are trying to balance between shareholders and other stakeholders like the environment, their employees, et cetera, et cetera. The Benefit Corporation, or B Corp, is a potentially form that you might want to think about. It basically is just like any other corporation. The taxes are the same as any other corporation, but it allows the directors to balance between all the stakeholders. And I can talk to any of you guys more about it if you're interested. I don't want to go too deep into it, but it has a higher level of accountability and transparency. And I was actually, I worked with a lot of social entrepreneurs who were interested in building these kind of companies, but we're finding that nonprofits weren't the way to go because you can't get investors. You can't scale them. You can't, really get the kind of, return investment for yourself that you want, because all the nonprofit assets are dedicated to public purposes. So we really invented this new form back in 2012, and now there's thousands of these companies in the United States, some of which are going public. A couple have started going public. Etsy's a B Corp, for instance, if you know Etsy. There's a university that went public on the New York Stock Exchange, but thanks for asking, because I'm pretty into it, actually. If you're a mission-related for-profit company and you want to create a better product or service, and it's telegraphed to the world about that, the Benefit Corporation is a really good potential for you. Yes, sir?
Yeah, I have a question on the voting rights, because seems like some equity holder, the founder can hold 20%, but they actually hold the rights, like 51% rights of voting. How's that going?
You mean with the Benefit Corporation or just generally?
I'm talking about the corporation.
For any corporation?
Yes, just for zero now, if we are
Okay.
to see.
So, you can, so sometimes preferred investors negotiate special rights through contracts. So let's say they just have 20% of the shares, they put a lot of money in, they diluted you down, you have 100% now, but we're gonna take in a bunch of money, and at the end of the day, you're gonna have 80% of the company, they're gonna have 20% under your example. But their preferred rights that we talked about earlier, I think through the preferred stock, is one of the things that, where was this? I don't know.
Because the Facebook owner, right? He's actually only on 70%, but his rights like 51%.
So that's negotiated, right? So when we start with a common stock and then we kick an investor in, it's the reason why it can't be an S corporation or an LC. Because then the investor's gonna come in and go, okay, well, I wanna get paid first. I want my return on investment. I want voting rights. Here's what I want to veto on. I want to veto on if you take in debt. I want to veto if you change, senior management, if you're going to change business purposes, if you're going to, reincorporate. So there's a whole bunch of things that you do negotiate with preferred stockholders, rights that they get either through the preferred rights or through a contract called an investor rights agreement. It's all negotiable. There are some certain standards about that. There's certain ways to do it, and we always say on the West Coast there's kind of a Silicon Valley way of doing things. We do things kind of one way. Out here, when I deal with venture capitalists on the East Coast, it's very different, and they're much more difficult to deal with. So all of this is negotiable, right? And it really depends on if you can find either a venture capitalist or an angel who believes in you and what you're doing, and then you have to negotiate, hopefully with a good lawyer who's done it before, who can talk to you about what's market. Does that answer your question?
Yes.
Generally? We haven't gone into the actual details of it, but it's typical. You're definitely gonna be giving up, and also they're probably gonna want a seat on the board. They probably want a seat on the board if they're putting enough money in, usually.
Can I ask you a question?
Yes.
We're an LLC because our lawyer said since we were investing so much money, it'd be a good write-off for us. But I had done some research, and it shows that if you file a statement of conversion, that with the secretary, then you can just convert it to a C Corp?
You
Is
can
that
convert
true?
an LLC to a corporation.
Okay,
Statement
good.
Conversion.
But probably should go through a lawyer,
I would recommend.
Okay.
Let me tell you
I might
why.
have to talk
This
to you
is
about
my
that
this
later.
is my last slide, but I'll just mention to you. I know there's a lot of services. There's also a lot of great lawyers out there too. But if you're doing a startup, you should be able to get kind of a pretty good. We'll talk about a package that we offer. There's a lot of good startup lawyers out there, though. They're offering packages and things like that. The problem with going through either yourself or some of these online services, almost uniformly I find they do it wrong. They do it wrong because the documents are incomplete. They don't assign the IPN, the conversion is not properly filed. So, you can sometimes get away with it when it's just you, but the minute you either get employees or you get an investor that looks at it, then you kind of get a little bit of problem. And the big thing is, if you're really serious about scaling your business and getting an investor, they want to come in and see that you've created your company in a professional manner, right? Because they're investing in you, they're investing in you as a professional, not just your idea. And it will say something to them, I think, if they've seen a lot of these kinds of companies, if they see a corporation that's not set up correctly. So when I go out for investment with my companies, or even with this company I told you about that's negotiating with a big French public company, we spent months, this company's been around for 18 years, we spent months getting all their documents together before we went out for this big deal, right? took a little bit of work because they're busy doing their business, but they haven't always crossed their T's and dotted their I's.
Right.
But we want this to be a beautiful package for the investor to come in and
Right.
go, check the box, check the box, check the box.
Okay.
That's what you're doing to try to save yourself time now.
Okay.
But there are definitely strategies when it's just you until you kind of get more into it, where I
Yeah,
understand
it's not
people
just
are,
me, so
yeah.
I might need
Might
to
be
talk about
time.
that later.
might be time, so, yeah, so, okay. So I wanna raise a tax consideration, which is a little known thing that my tax, specialist asked me to put in here, which is a really good thing to know about a C Corp. This 1202, Internal Revenue Code is really a boon for investors. You know, if your company doesn't make it, it doesn't matter, but if your company makes it, this tax code, will really help the startup, stockholders. You can exclude $10 million of capital gain when you sell the company. But you only C Corps can do this. And so if you have to be a C Corp on the day of incorporation, and you have to hold the stock for 5 years to qualify for the exclusion. And the reason why you don't want to be an LLC, getting to your point, is the holding period doesn't start until you convert.
Okay.
So, you know, you've got a basis in that LLC right now, and you want to get to be a C Corp as quickly as you can so that you have a low basis when you convert, so that when you hopefully sell the company one day and make a whole bunch of money, you know, the differential will all be subject to a bigger capital gain than if you wait too long, because you have to have that holding period, right? So there's tax reasons to do that too, so actually, thanks for the lead. Sir?
You're talking about the C Corp and the LLC, and, you know, having it for 5 years. Can any of the others, like the B, convert over?
So the B Corp, I know this is really confusing. The B Corp, the benefit, let's call it a benefit corp because it gets really confusing. It's already a C Corp for tax purposes.
Okay.
Yeah,
So
So
like
the LLC
this
isn't?
exclusion applies to a B or no?
Absolutely.
Okay. I'm just
absolutely.
curious.
As long as it's taxed as a C Corp, it will apply to a benefit corp as well, which is a for-profit company just like any other. There's a California benefit corporation, there's a Delaware one, and other states too. Okay, so, let's see. So we talked a little bit about taxes, and, so have you guys worked with lawyers before, or is this all kind of a new process? Hopefully you didn't hate them too much, I'm gonna try to make it painless. How do you engage with a lawyer to start? First of all, try to find somebody that you like. You're gonna be kind of married to this person just like your co-founder. So it's, I think, really important to shop around and find somebody that you get along with that shares your kind of gestalt, your ethos for what you're trying to do, that's excited by what you're trying to create. I also think personally, if it were me, I would focus on somebody that knows how to do startups. And somebody who knows how to do startups where you are. In other words, sort of the West Coast model. I recently dealt with a lawyer who was who's in Southern California, who's worked with a client of mine who's leaving that law firm because they work with huge financial institutions. They don't really know how to work with nimble startups. And so they over-lawyer everything, my client says, and that's why they're actually leaving this law firm. I think you need somebody who really kind of understands the right touch, how much of it, you know, to reduce your risk and get you what you need, but not over-lawyer it as though, you know, you're ExxonMobil, right? Which has focuses in dealing things in a different kind of way because they're huge corporations and they have to have different kinds of policies in terms of how they write contracts and so forth. You want it kind of, you know, it's like the Goldilocks method, not too hot, not too cold. So whether it's me or somebody else, interview your lawyer, ask them how much experience they have actually starting corporations, getting financing and doing contracts and this kind of thing. So for us, we would ask you to sign an engagement letter, which is our agreement about what we're doing with you. We have an incorporation questionnaire, which we ask you to fill out. We review the incorporation questionnaire, and we ask you to kind of check for any obvious trademark or naming issues. If you want us to check the trademark, we have to do a search, which costs a little money, and we can do that for you. And we can also help you file for a trademark, but we'll talk about that in a moment. And then we provide you with customized incorporation documents, and I'll talk to you more in a minute about what those are. Okay. All right, and so what's the terms of engagement for working with Founders Institute corporations? Either one of two things. Either To get this package we'll talk about in a moment, you pay our fees and costs, but we offer you a flat fee of $2,500 to do the entire incorporation package. Plus we collect about $1,000 for the costs. The costs are filing fees, which I'll go over in a moment. They're not for us, they go all to the government. And there's a whole laundry list of fees that go out in order to file a corporation. We can potentially defer the fees as well, and we would offer you, if you qualify for a $5,000 deferral, we still collect $1,000 because that's out-of-pocket costs. In return for deferring the fees, we ask for a 0.25% equity issuance for our law firm, which we pay for, but of course the corporation is very low valued, so it's not very much in the door. If we defer the fees, we ask you to revisit the issue upon a $300,000 financing or 6 months after we incorporate the company. If the corporation needs more or other legal work, we ask you to pay for it. We can do a budget, budget by budget, project by project, depending on what it is. I'll talk to you a little bit more about those fees in a moment. I want to talk to you about what kind of documents you get, what kind of documents are created. So the first thing we do is draft a certificate of incorporation. Most of the time that's going to be in Delaware because you guys are probably mostly looking for institutional or venture capitalists. And those kinds of investors that I talked about earlier are generally going to focus on Delaware corporations that register in California. Sometimes we do California if you're only looking for a couple of angels that you're very close to and they're in California, and that's all the money you need to bootstrap and then scale, but generally Delaware.
Yeah, LAFI requires them to be Delaware.
Yeah.
Can I ask you a question? Have you done some research on that? And they basically said if you're in California and you're doing business in California and you incorporate in Delaware, you're going to be taxed by California as well as Delaware.
You will be.
So it's double taxation.
Well, kind of. I mean, it's true, you'll have to pay the franchise tax in Delaware. There's no ways to keep that to a minimum. But if you're, regardless of what corporation you are, if you are operating in California, if you have a principal office here, you have employees, California's taxing you, you have to register.
So why
No
would
matter
you,
what.
So then how would that benefit you to be in Delaware and get taxed by both?
So the reason you want to be in Delaware is because investors like Delaware, and they're going to require you to do it. Institutional
Really?
investors,
Yeah.
pretty much all of them. And that's why the Founders Institute model is requiring Delaware, because they're focused on helping you scale, and you need money to scale, and money comes typically from institutional investors. So.
But it does come with double taxation.
Yeah, but there's Delaware. There's a way to do that is fairly minimal.
Okay.
They won't tax you on your entire income if we set it up correctly. And frankly, if you do really well, you'll be happy to pay the tax.
Yeah. Okay.
Most public
I've never been
companies,
happy with
public companies are Delaware corporations, and because they're public, they make a lot of money.
I just got in an argument with my co-founder about that, and I was like, I'm not getting double tax, but it sounds like you say it is a good thing to do.
If you're looking for institutional money, venture capitalists or sophisticated investors, they're going to require a Delaware company. You'll note the B Corp's on here too, and you can do a Delaware benefit corporation or B Corp as well. So that's kind of the birth certificate. It's going to state your name, and it's going to state your agent for service of process, the amount of shares you have, and things like that. We put some things in there to protect the directors, but it's basically the corporation's birth certificate. The action by incorporator is something I fill out that says I incorporated this thing, I appoint the initial directors, I make it easy for you and set the whole thing up. And you'll see all these documents if you work with us, right? The bylaws are a lengthy document. It's kind of the rules of the road. It's kind of like your Bible of how you operate this company. It says what kind of officers you have, how you have to have meetings, how you have to have, what kind of directors you have, what kind of reports you give to the stockholders, and the kind of information rights that people have. Sometimes you amend those as you take investors in, but it's basically the rules of the road for how you operate the company. You can think of it as kind of like the manual you get to operate your car.
Is that fairly standard, or does that vary from incident to incident?
I'd say I would suggest keep it pretty standard when you start out as a kind of you and one founder, something like that. It differs depending on if you're. It would differ depending on what state you're in, but it will also differ a little bit if you're a benefit corporation, because there's sort of different duties. Try to make them as similar as possible, but try to make a standard package. I absolutely advise you that. There's another reason to do this too. There's no reason to keep. I mean, these documents are complicated enough. it's best to keep them as standard as possible. Also because when you take investors in, they're gonna look at this thing and again, it's check the box. Does it look like this, or is it some strange oddball that they have to try to go through and configure, which is kind of a turnoff to angels and venture capitalists, right? They want kind of a standard package. And so again, best to work with lawyers who know how to do startups and aren't gonna kind of create funny, weird kind of stuff, or incomplete stuff, which you'll find from a lot of online services. Certificate of adoption of the bylaws. This is the secretary's certificate that says I'm the secretary, I adopted it. We'll give you an initial board consent. The initial board consent will issue the shares. It will have a number of things that will be adopted, you know, like you're gonna set up a bank account, appoint the officers and things like that. Then you'll have a stockholder consent, which will consent to also appointing the board, and will also authorize the equity incentive plan, which is required by the stockholders to authorize it. Then we would have, what's that?
All these documents.
It's a lot of stuff.
I know.
One of the things, by the way, I want to say,
Corporation, and then you look down below and
it's a lot of stuff.
Yeah.
One of the things I wanted to say, it's a little daunting though, I don't know all these documents, what am I gonna do for it? One of the things we've actually tried to do, that I've noticed, that, as I said, there's a lot of really good startup law firms in California that are really adept at it. And some of them have these online packages that we offer. When I've gone and tried to research it, one thing I've noticed that we've tried to do is we've given you more for the same amount of money. Some of the law firms, I'm not criticizing them, by the way, because everybody has their package, but we've tried to make it so that when you're out the door, you don't actually have to come back to us unless you're doing a deal, right? You've kind of got everything you need. So some of the law firms may not give you certificates of certificates, stock certificates, or a stock ledger. Some do. Some give you, you know, the equity incentive plan. Some do, some don't for their package. So when you shop around, you know, use this list and think about it and ask, okay, you're asking me to pay X, Y, and Z. Are you giving me this list? You know, and you can decide whether, you know, are they giving me the complete thing I need? Do I need that? Or do I need it now, or will I wait till later? So, restricted stock purchase agreement. This is for the founders to buy their stock, and typically the way and why is it restricted? You're going to pay a little bit of money and assign your IP in to the company in return for your shares. What does it mean to have restricted stock? It means that you're going to be subject likely to vesting schedule, and I'll talk about this in a moment. But that's why it's restricted, and the stock is subject to repurchase. Why are you doing this? Because investors like to see it. They want to see that you've got skin in the game. You're going to stay in the corporation. You're not going to just put your money in and leave the corporation, take your shares, and never come back. So that's why it's restricted, so you'll vest over time. The notice of issuance is like the stock certificate. I'm doing these, they're like little letters, and the reason why I'm recommending to my startup clients to do this is because everybody loses their stock certificate. So this is an alternative. It's a little letter, and you keep, you know, it says your stock is issued. You have a stock ledger, a simple stock ledger, which lists all of the founders' names. We can get fancier later, but for the beginning, it keeps things really nice and simple. If you lose the notice of issuance, I don't care, right? And then later, when the investor comes in, we can do something else again to prove that you're the owner. Not a big deal. But getting stock certificates back, or you've lost them, we have to do an affidavit, there's a whole bunch of more. You have to hire me to write a bunch of stuff, cost you a bunch of money, and who needs it?
And this is what contributes to the timeline, like when somebody says yes, they'll give you money, and then when it gets to your bank accounts, because you're going back looking for all these.
You're going back, you're calling me up, you're charging me money, Jonathan, why do I have to do this? Why all this paperwork? And so we try to do it standard, as simple as possible, so you know we can reduce it. So we're going to do an equity incentive plan. Some people don't do it, but I recommend, you know, if you're thinking about scaling and having employees who are going to work for equity, I would do it right at the beginning and just get the plan in place. We've drafted something that's very flexible for you. When you start getting into the details, okay, I'm going to hire this CMO, I'm going to hire this new CEO, or what have you, then we can start talking about what kind of grants. My wonderful employee benefits partner wrote this alert that I gave to all of you. You can read it later on, but it talks to you know, a lot of detail about what's an equity incentive plan, what's restricted stock, what's a stock option, you know, what kind of things go into that, what's an RSU, or restricted stock unit. So it gets into the details of what this equity incentive plan is and makes some recommendations and things like that, which we can think about offline. But you know, I would start with a really broad plan, a vanilla plan. It's got everything in it, and just be done with it. We give you stock option agreements, so when you're issuing the stock option, the employee signs the option agreement. It has all sorts of bells and whistles, particularly those that will allow you to get, for vesting and also to get the option back, basically if they don't stay with the company. Or something happens where you get bought out. There's acceleration provisions and other kinds of provisions that protect you, the company. We also give incentive to the employee to come on and give them a good feeling about being part of the company and work really hard to scale the company, because that's really what it's all about. Then there's a number of sort of stock agreements we give you to get you started, because the first time you do your first deal, this is another thing, I usually don't see a lot of other law firms give you some of these agreements, but not all of them. But the first thing out of the door, the minute you start talking about with somebody you're doing a deal with, you want them to sign a non-disclosure agreement so they don't learn about your company and take the idea. So we give you a mutual non-disclosure agreement. The founders ought to sign an at-will employment and confidentiality agreement and sign their IP, and also for your other employees to keep the things confidential, sign their IP. And one of the things I always warn entrepreneurs about is to make sure you own your IP. I often hear people say, yeah, I'm working on this IP with my best friend and doing this, and he doesn't want, or she doesn't want anything in the company. They just really want to be helpful for me. I can't tell you how many times I've heard that. They won't care about it until you're super successful. And once you're successful, they'll come back and say, we had an agreement. You promised to give me half the company. And then we've got a problem. Because you will, by the way, if you're doing a deal with investors or you're selling the company, you will have to give a representation that you own all the IP.
Can I ask you a quick question?
And if you can't say that, you'll have to indemnify them or you'll lose the deal.
Right. See, my patent attorney told me to keep the IP under my name and to license it to the company. Is that acceptable, or?
It's going to be acceptable until you get an investor.
Like Founders Institute, or will they?
I don't know about Founders Institute, but a sophisticated investor will come in and go, I'm not giving you money so that you can get a license. You put your IP in.
I see.
Or not. So
Okay.
you might get an angel that says okay, and then negotiate if it's a irrevocable, exclusive kind of thing. But by that time, it basically is the same as owning it.
And I will say, I've had to do these individually with lawyers where that's a great deal, because I've spent a lot of money on each individual thing. So yeah, that's great.
Yeah, each one of these can cost as much as the package costs.
Right.
Or more.
It really can.
So what we've done is we've tried to put a package together that we've semi-automated. That's why I can bring the cost down. And what we have is a corporation questionnaire with a few little tweaks that gives you standard packages, and we try to keep it standard just to get you started. If you're going to get an investor in or something gets fancy, we can revisit it. But start out kind of with a standard package. Pretty much has all the bells and whistles in it.
And if you keep it standard, it's another thing that de-risks your company for financing.
Yeah.
Because they have all these people approaching them, and you've got a wacky incorporation or something, they just move on to the next deal.
Because they don't want to spend that much time looking at it and figuring out what you've done.
Yeah.
They want to be able to, okay, I know what that looks like, I've seen that before.
And it tells a lot about the underlying operation of your company too. If that's all, your legal's all orderly, they make the assumption that everything under it is pretty orderly too.
Yeah, really
So,
important.
that's just a high level look.
And I would also say, and again, this is not to stroke my own back, but often they'll want to know who's the lawyer you're working with. Is it a law firm that does this kind of work? That generally gives investors some kind of confidence. Indemnification agreement, what is that? That's so when you have directors come in, there's statutory protections for being a director, but usually a sophisticated director is going to require a contract. It basically says the corporation will promise to indemnify me against my work for the corporation as long as I act in good faith. And so it's a standard agreement we give you that every director, of course you're all going to be directors, so you want it too, right? Because right now it's just you maybe, or you and the founder, but this baby that you've just created is a different person. It's not you anymore. And the minute, particularly if you start growing, you have investors, you'll see you're a director and an officer, you're a founder, but you're just one, if you scale, of many. And so you want to have these contractual provisions and protections for yourself as well. The advisor agreement is if you maybe you find a number of really well-placed individuals who can help you scale the company and provide advice, but really aren't on your board of directors. You issue them maybe some options to allow them to participate in your company. And so there's an advisor agreement that we've created that allows them to come in and talks about how much time they will participate. It also, based on the Founders Institute model, talks about how many options they will get based on the where you are in scaling your company and how early stage you are. And so there's sort of a scale of how many options you give them for the advisor. Consulting agreement, if you have an independent contractor, they're not an employee, but you're gonna go hire somebody, you know, in Ukraine to do coding for you or where have you, you want them to sign this consulting agreement. It assigns all the intellectual property into the company and make sure that they also keep it confidential. Really important, because unlike, remember I said earlier, if you're an employee, there's a presumption at least that the company owns it. With the consultant, the contract, there's no presumption at all. And you don't actually own the copyright. You don't actually own it. So I always like to give this example of like a book. When you go into, you know, like a bookstore and you buy that book, you own that book, right? So if you, the company, buy that book, you'll own it. But guess what? You don't own the copyright to that book unless you have an agreement that says, I own all of the right, title, interest into the copyright, okay? So you need this consulting agreement, not just to buy the book, to get the code, to get the software, but something that says in writing, because it has to be in writing or it's void. That says, I own all right and title interest into this copyright, all the underlying intellectual property, or you don't own it. You only own the book, not the right to
You mean
reproduce it.
between you and the person that's
Yeah,
creating the
yeah, yeah, really, really important. Really, really important. So if you got a programmer, you got somebody doing marketing, you know, they're creating a business, whatever it is, they need to sign all of the intellectual property, copyright, patent, whatever it is to you, has to be in writing.
So let's start online service like 99 Designs, where they have created a logo for you. Are you familiar at all? Or if you just do an online service where it's like Fiverr, where very small deliverable, you may never even work with the guy again. Do you need assignment like about each of the
Yes, you do. You absolutely do. If you want to use that logo and you want to own it, sure, yeah, you absolutely need to own the copyright in it, in the actual logo. So they're producing artwork for you, or what have you. They need to assign all their copyright interest in it to you.
Okay, so you need to so that could be part of their boilerplate agreement.
It could be. I would check it and make sure. Now, look, there's also software providers that do this for a living, right? They start out with their own engine, if you will, like their own platform, right? So a little bit like if you were building a car. So Chevy has their own engine in the car, and they build it to look like a Pontiac, or they build it to look like a Prius, or whatever they build it like. So you at least need, if you're doing software, you at least need an irrevocable license to use the engine, and then you own the copyright in the thing that's been created that customizes that thing for you, right? So if it's software, that's how you can work it. But there are software providers, that's what they do, right? That is their business, is to create custom software for people. They might need to continue to own the platform upon which they build it. But they can give you a license for that piece, and the customized software that they build should be assigned to you. So that's the kind of thing we would work together on and looking depending on what you're doing. But artwork and stuff like that, you want to make sure you own the copyright in it, all the marketing material. And actually, I would actually want them to rep that they actually have the right, that they authored it originally, that they didn't take it from somebody else. Because then you've got a lawsuit if they didn't do that. We would want them to stand behind it. Does that answer your question?
So if they don't even have the assignment themselves, they're signing away the assignment, but they don't even have it.
Well, they could have had somebody else do it, just like, remember we were talking about the consulting agreement? They could have had somebody else do it, they may not own it. I want them to represent and warrant that they own all the right, title, and interest, and they have the ability to assign it to you. If you're gonna pay them money, you wanna know that what you've got, and you wanna have somebody reputable that can stand behind it. Because if you're sued, if somebody comes out of the woodwork and sues you, then you want them to stand behind it, right? You don't wanna, as we say, don't wanna buy a lawsuit. You wanna buy intellectual property, not the lawsuit.
So how is the stockholder of restricted stock have control over the IP? Do they have, or they just?
So the company should own the IP, not the stockholder. Now you created the IP,
Right.
but in return for assigning your IP into the company, now you own stock. But the company has to own the IP, all the assets of the company used to scale the company.
So And what about?
I mean,
the,
you'll be on the board of directors, right? So the director will make decisions about how to use the IP, how to scale the IP, whether to buy it or sell it or what have you, but that's how you'll exercise control. It's not really so much as a stockholder or the creator anymore, but as a member of the board.
So when is the next time you apply for your IP or you just keep it a trade secret? When is it? What is the options? And
So it's a little bit beyond this.
Oh, okay.
There are, so IP is either a patent, a trademark, copyright, or a trade secret, generally speaking. And I have clients that, let's say in the software business, that never patent their software. They just keep it as a trade secret. Because as a secret, there's no ending on the protection. The most famous example actually of this is the Coca-Cola formula, right? That's the most famous one. So nobody knows how to make this formula. They don't have a patent on it. They don't have a patent, there's not copyright protection, there is no government protection for them. The reason why this formula is so valuable is because they have it locked up in a safe in Atlanta, and nobody knows how to use it. That's also why you need a non-disclosure agreement, a confidentiality agreement. If you let anybody know about your trade secret, if they're working with you, they need to agree to keep it secret. Because the way you keep a trade secret protected is by showing a court that you've done all the things to keep it protected. You keep it locked up, you only tell it to people that need to know. You've got a contract with people you give it to that says it's confidential, it's a trade secret, they don't own it. So we would work together potentially on what's the best IP strategy depending on what you're doing, right? Whether it's patentable and it's worth doing a patent, sometimes it is, sometimes it isn't. Generally these days, like with software, not so much. If you're gonna do a, genetic coding or, pharma, probably is. But there's sort of different things you look at. Trademark, of course, is about branding, using the artwork and the name and the logo. Copyright is things you put a written expression. I've actually got a whole, PowerPoint if you guys want to see more about it. We can talk about it again.
So a trade secret, hypothetically, if it got out, it's not protected. If somebody just like leaked it, then it's out there for the world.
If the company doesn't protect it and tells the world about it, you can potentially lose trade secret protection. Exactly. Sometimes people go rogue in that, and then you're into a lawsuit. Sometimes the employee steals it, or someone has leaked it. The best way to show people it's a trade secret is to show that it really is confidential, proprietary information. Sometimes we have people that ask us, well, we've got this customer list, right? My customer list. This employee left, and we're going a little off topic here, but it's okay. My employee left. She knows all these customers. And then that's a trade secret, right? I mean, nobody knows about it. And it really depends. That's the biggest example. If you go on your website and you have all over your website all your customers, because you want to brag about your customers and tell everybody all the great customers that you service, City National Bank and Ernst & Young and Wells Fargo, it's not a trade secret. So I've had many clients come to me and say, this is a trade secret, and they're going to contact all my customers. First thing I do is I go to their website, and they're going to list all their customers there. It's not a trade secret. And it might not be anyway, even if you don't have it on a website, because it's really how commonly is it known, how much protected have you kept the clients, even within your own organization. So, it's a really, you kind of have to get granular on this kind of stuff, right? But if it's really, really important, if it's the secret sauce, you really restrict the secret sauce even with your organization to the people who really need to know. And you have them sign this invention confidentiality agreement I had. So.
Hypothetically, if somehow the Coke secret formula was uploaded online, which is NBC News says somehow all the formulas there, and it's public and it becomes public information, a company or maybe 5 or 6 companies decide, we're going to market the formula, we're going to build the Coca-Cola, use the formula. Does Coca-Cola have anything legal there?
Depends. I mean, if Coca-Cola leaked it, if they did it.
Not Coca-Cola. No one knows who leaked it. It was a hacker, and everyone found out. And they can't find who leaked it.
Yeah. So if we can show that Coke did all these great things to protect it, and somehow it ended up lying, and nobody knows about it, I would say that they would rush to court and file an injunction to remove that and enjoin all those parties that tried to steal it, And if they
It
did
was-
something
it
about
was-
it.
It was there, it was there available for.
Yeah, but if they took it and they should have known that the code formula, no, look, if you're gonna take the code formula, you probably know it's a trade secret. Right?
Oh, so you're saying that,
I was
okay,
saying-
so Coke would still have legal, even though it was there, because it's stolen property that's not public.
It's stolen property that's not public, so I would say, if a client called me up and said, the code formula's online, I'd say tread, I mean, it sounds great, like, take it. I would tread really lightly, they're gonna be on you, and they're gonna immediately go to court to have whatever that server is taken down, and they're gonna find everybody that downloaded from that site, and they're gonna file a lawsuit against them to enjoin them, to get declaratory relief.
What about modifications, like if they
Sorry?
use, what about modifications, if they use the Coke formula and change like one thing, does it still apply to them?
Because it started with the code formula, so the modification is based on intellectual property. Or let's just say you had a software, right? I stole your software, but I just kind of changed it a little bit. Still, the origin is from you. Now, there's all sorts of nuances to this, but yeah, basically, people would be on this own. Sir?
So I've got a quick question. So I'm working on a product that happens to be related to skincare.
Is it a code formula?
If we can put the Coke formula in a skincare product, that'd be great. But the companies have to list the ingredients in order on all the sites. What happens in the industry is people take a formula, they just tweak it, and they come out with their own. So is there any protection there? Let's say we're working with a chemist right now, and we have a formula. That chemist is working with us, but it's common knowledge that a lot of this stuff looks the same. Is there any protection? Do they need to sign something?
Are we worried about the chemist, or are we worried about somebody reading the back of the label and trying to recreate it?
Probably worried about the chemist. I mean, I think it's probably standard practice in the industry that people just take this and they tweak it and they come out with their own formula.
I mean,
So-
if I'm paying the chemist, I would
Yeah.
want him to sign an NDA, and assigning what they're creating to me. Now, if someone reads the back of a label and can reverse engineer it, I mean,
Yeah.
look, if you read the back of the code, if you can actually reverse engineer the code formula, you can use it, because it's just a trade secret.
Yeah.
You could actually take that code, and they still be on you, so it's don't go try and create the code formula. But you can reverse engineer a trade secret. You could take it but it's the point of it being a secret is you're making it really hard to do, right?
Yeah.
But it is the downside to not having a patent. A patent is a monopoly. You can publish in fact, you have to publish exactly how to create this patent.
Yeah.
But the government gives you a monopoly as a way to encourage you to create great stuff. But if it's a trade secret, and you can look at the back of that label on the back of, that thing of applesauce or whatever, you can figure out how to make this the same taste. Have at it. I mean, that's how Pepsi started.
Yeah.
That's how Mr. Pibb started. They tried to do that, right? And then so that's kind of what that's about. So, but yes, if someone were working for me and creating a formula, I would want them to assign it to me and
Right.
me not to use
But
it.
we would want to create the legal documents in the formula we created, even though we know somebody could reverse engineer it off the back of a label. I mean, it is.
So if they, well, now you're getting complicated on me, but if you're taking, they look at the back of the label and say, well, let's try to take these basic agreements and start, ingredients, let's try to start with that and make our own formulation. Yeah, I would want it, because I want that formulation to belong to me. I wouldn't want he or she.
Right, I mean,
to go out
there's ratios and everything else that are important. And yes, they could reverse engineer it, but it would probably be not exactly the same based on how the ingredients work together.
But your chemist, you don't want your chemist to
No,
go
right.
off and do something with it. If they can reverse engineer it on the back of the label, then we're
Okay.
kind of into whether you're allowed to do that or not.
Thank you.
Strategies aren't trademarkable, right? Like, they're not trade secrets. For example,
Like-
business strategy, marketing, sales strategy. They're not trade secrets. So to
I mean, if you keep it secret, it's secret. If you don't tell anybody, it can be a secret.
Because, I mean, for example,
Or
you
if
use
you-
strategy in one company, you use strategy in another company. I mean, I know, you know the strategy, but the company doesn't own it.
Is it a secret though? Is it really a secret? I mean, the question is it a secret?
I mean,
Or does
is
everybody
it a
know
secret? Like, are you broadcasting your strategy? I mean, eventually it comes out, right? Because you're implementing the strategy. But before it's implemented,
It could be. It could be, and it really depends on how the company handles it internally and whether what they're doing is common knowledge. So you can't, there's an example of this, of somebody taking in, if you took the phone book and you recreated the phone book, but you did it yourself. It's common knowledge. That doesn't make it a secret just because you created it and you put it in a safe. So you kind of have to kind of drill down on what this means. So if your strategy is the common strategy, everybody knows these kind of things in the business, you're creating your own and putting it in the safe doesn't make it secret if it's already common knowledge. Also in the company, I would say, sometimes I have clients that say, well, everybody knows about this thing in the company. That can make it problematic. I would say you try to restrict it with a need to know to only the people that really need to know that, whatever that thing is. That's a way of really protecting it. So if even a rogue employee gets a hold of it and they really didn't have a need to know and then they leave and steal it, that's a potential way. But it has to really be a secret. Yeah. Some of the things get down to, you know, individual things too.
If your product or service has kind of like a storyline to it, how powerful is a poor man's copyright? The one where you mail it to yourself and don't open it.
So the minute you, under US copyright law, the minute you write something down, like this thing, well, maybe not this thing, I don't know, because there's a lot of common words, but the minute you write something down, an idea is not copyrightable. But the minute you memorialize it in writing, you have it copyrighted as your original work of authorship. So it's not required anymore. It isn't required to register something to get copyright protection, but you're wise to do it because there's all sorts of extra goodies like potential statutory damages, and you don't have to prove your damages, that you want to register the copyright for. So, or if you're using it to brand, is it a branding element? Because if it's a branding element, if it's a tagline or, you know, something like, I don't know, then you might go try to get trademark on it, because trademark is about branding your products and services with either a logo or a word or a phrase, right?
It's more of a storyline than a tagline.
So we have to kind of figure out, is this copyright protection? Is it a trademark? Are you marketing with the storyline? And how are you using it? Then you need kind of an analysis of what to do and kind of what the best way to protect it. And how are you trying to monetize this storyline, right? So you have to kind of sit down with an IP lawyer and kind of try to figure out what the best way to protect it is. Or whether it's worth protecting. Sometimes I actually have people that don't protect stuff because they don't care. They actually want as many people to take it as possible. Actually, you know what? I'm going to give you an example of this because it's kind of crazy. Remember when we were just talking about the B Corp? So the name of the corporation that I helped invent is actually the Benefit Corp. But there's a nonprofit called B Labs, and they had a certification called a B Corp certification. My law firm has a B Corp certification. It's a private company certification by B Labs, saying you took this test and you qualified to be B Corp certified, and so as a more socially responsible kind of company. Well, so the B Corp people though, they're really trying to get this idea about B Corp out into the nomenclature, and they don't care about monetizing it. They just want everybody to think B Corp. So they have purposefully allowed the Benefit Corporation, which is actual corporation, and this B Corp certification to kind of mix up a little bit. They wouldn't be able to get a trademark on it anymore because they genericized it. So everybody says B Corp. When it's B Corp is really a certification, not really that. There's other places have done this by like Trampoline. That was a trade name at one point. You don't think about that anymore. Or Kleenex. Kleenex, it doesn't mean tissue. It was a brand, but now everybody says Kleenex. So they've lost their ability to stop people from calling it a Kleenex. So you kind of get into these brand strategies and how to protect things, and when you do them, and how, if you don't do them the right way, people start using these names and referring to a common object, right? But they didn't start out that way.
Ironically, that's Coke in the South. It doesn't matter what you order, you just order Coke.
That's true. Yes, that's true. Okay, so, we haven't got any more questions? And we can come back to stuff too, but I want to make sure we're cover the rest of this stuff. You talked about consulting agreements, so protect your IP. Get these people to sign their IP to you. Then we've got to, when we issue your stock, we have to file. So stock is either, when it's issued, is either registered with the government or it has to have an exemption from the registration. I won't bore you with a lot of details, but you have to file securities law notice. We have to figure out an exemption. For founder stock, it's pretty easy. Typically in California, we use the securities notice 102, which is pretty basic. There's a little cost to that. Why do you care about doing that, by the way? You care because of what Janine said. The investor comes in and wants to know, did you file your securities law notice? And why is that important? If you don't have an exemption, if you haven't filed correctly, all the investors have a right of rescission. They have a right to actually ask for their money back, even if they haven't been damaged. So when you're doing well, no problem. Everybody stays in. It's awesome. But when the company starts having a bad year, all of a sudden they hire a lawyer. I don't like the way this new CEO is doing this. I want to get my money back. They start looking at the corporate documents. The exemption wasn't filed correctly. They actually have a lawful right of rescission. Please pay me my money back. And it could be a lot of money by that time, right? The company could be worth a lot. So that's why these terrible things we have to do, it seem like they're, why are you spending this money on doing these legal things, are actually really important for the long term to protect your company and your own investment. So also, we can talk to you about trademark advice and doing forms of offer letters and other kinds of things as your company expands, or you need to do things at the beginning, but there is an extra charge about it because, as you can see from our talk, it's not kind of off the shelf. It's based on your storyline, your logo, your patent, so we really kind of have to get into what you're doing and try to tailor, what's right for your company, and try to figure out the best way to search and clear whatever the IP, and then to figure out the strategy for protecting it. And also, by the way, you do US stuff, and then you have to think, am I going to go international? What am I going to do international? So,
What about stock photos?
stock photos that you
Or
download
stock
online,
records?
You have to buy a licensing, right?
you have to get a license.
Yeah, so part of your subscription, you would get a license, and let's say, for example, I have Adobe stock, I use different graphics there.
That's okay as long as Getty, it's usually Getty or one of those outfits that gives you a stock license to use on your website that has a pretty picture of, whatever it is. That's okay, as long as the license covers what you need it for, that's okay. I actually have a client that, I felt so bad for them. They're a nonprofit, and they had they're this membership organization, and they allow you to blog on their site, and they put a picture of one of the founders of Google. They posted that had been taken by a photographer, and they got sued by Agency Press, some French outfit that took the picture. And then you get some we call them copyright trolls. Law firms, that's all they do. They send you cease and desist letters and ask you for a bunch of money. So this poor nonprofit, one of their members blogged with a picture of the founder of Google on the web and said, well, Google wouldn't do this. And it wasn't a bad thing, but it wasn't their picture. They downloaded that picture, they posted it, and then they want $1,500. And if they didn't get the $1,500, they were going to sue us. And the point about the copyright, when you get the registration, there's a presumption you get statutory damages, which I think are about $150,000. So you get to be, I've actually been negotiating this with them, with this, and they spend more money. They've had to spend more money than probably if they just paid them, but they didn't want to pay the money to them. But they've now negotiated with these, we call them, copyright trolls. And I'm trying to argue for why this isn't a commercial enterprise and it's a nonprofit and you're killing my client and they have a right to ask. So anyway, point is get a license. Get a license. Don't buy a lawsuit. Okay. So what happens in the incorporation process? You've hired us or somebody. You sign the certificate of incorporation that we drafted or your lawyer has. We file it with the Delaware Secretary of State. Usually we can get it back, usually 24 to 48 hours. All those other documents we send you by DocuSign. I don't know how all the lawyers do it. I like to do it by DocuSign because it's all really neat, easy package, and we can track it. And you go obtain an employer identification number, which you can do online really easily yourself once you get the incorporation package back. Then you take that EIN, which is like your social security number, but for the company, and you can go open up a bank account with the certificate of incorporation. With the restricted stock purchase agreement, you're going to probably file an 83D election. I'll talk to you a little bit more about, let's talk about it now. We don't file that. It's an election that's attached to the restricted stock purchase agreement. And the reason why you file this thing is because remember I told you that your stock, even though you bought the stock, you put $100 in, it vests over time, it's at a very low value right now, let's say it was $100. You'd rather pay taxes on the value of $100 of your stock now, which is gonna be, I don't know, let's call it $20 or $30 now, than waiting for the stock to increase in value, and then as it vests, you will have to pay the tax on the difference. The 83B election allows you to pay the tax now based on the $100 valuation or whatever it is, so you pay the $20 in tax. If you wait till later, you're gonna pay tax on the, and we hope you're super successful, where it's millions of dollars. The last thing you wanna do is to have to pay the tax later on millions of dollars worth of stock. We want you to pay capital gain on that, not the initial tax. And then we do these securities law filings.
The important thing about the 83B is they have to
And
file within 30 days.
You get 30 days.
Counting weekends.
30 days, and
Counting
it's you either do it or you've lost it completely,
Forever.
which is also why we don't take responsibility for it. We tell you about it, but it's really important you get it in, and I recommend you file the darn thing and you send to the IRS certified return receipt requested, so that you have, because they lose it, and you need that for taxes, sir.
For conversions, will 83B apply to that? So if we went from LLC to a C Corp?
Only if it's restricted stock. If it's not restricted, then you won't have tax on it. But if you're doing a C Corp with investors, they're going to expect you to have restricted stock. And what they're probably going to do when they come in is they're going to say, unless you've really scaled, if you're pretty brand, it's a pretty still new corporation that hasn't really scaled yet, they're probably going to ask you to make the stock that you own outright subject to a vesting schedule. They're going to make you revest it. Do you know what I mean? In other words, why do they do this, by the way? And there's somewhere in here that I have, that's later on, about vesting, when we get to the shares. The reason they do that is they want you to have skin in the game and to stay there. They want you to have an incentive to stay and to get your stock over time. And so I'll talk to you about vesting, but we've had situations where, yeah, you bought your stock and you've been around a while and you're doing your thing, and then you get an investor and you go, wait a minute, if I'm putting my money in now, I'm expecting you to use this money according to our plan to hit those milestones. I want you to be in it in 1 year, 2 year, 3 or 4 years. We're going to create a vesting schedule. Now you're back to recreating, going back to your lawyer, recreating the documents, and to your points, more expensive.
Even if you invested a lot of money before that?
Oh, yeah.
Well, potentially, yeah, because if you're going to ask somebody else to put a whole bunch of money in, they want to know you're going to be in there, not leave. If people are usually investing in you, by the way, they're investing in you, they're trusting you. You've got an idea, but they're usually trusting in management to know how to scale it. So you're as important, as the IP. Otherwise, they could have done it. They could have invented the IP, and they could have gone and scaled it with the people they hired. But they're putting the money because they believe in you. So they usually want to nail you down.
And the other thing is if you start the vesting now, when they come in and put in money, and they usually don't start you all over again.
Yeah, they might.
Sometimes they do, but.
Yeah, or you maybe if you're through the vesting, then they'll issue some new options. We can do it through options, but yeah, these things are going to come up, right? But this is a good thing. It
Yeah.
sounds bad. You want people to invest. You want to be subject to the restricted. You want people to be attracted to you. That's a good thing, People always ask me, why should I go get investors? They're going to put this money in and dilute my 100%. You want somebody to dilute you because, 100% of a zero value is zero, right? 50% of millions of dollars is a lot of money. 20% of even more millions is even more money. So I like it when you get diluted. If you're smart about how we get you diluted and we get the money on it.
So the 83B only for restricted stock, right?
That's correct.
Not the common stock.
It is common stock, but our package will set you up with restricted. It's common, but it's restricted in that you bought it and you own it, but it's subject to repurchase by the company if you leave early. So that if the investor comes in, they put a bunch of money and go, I'm gonna leave, okay. You're not vested, the company's gonna take back part of your stock. Yeah, they're gonna buy your stock back at that original value. So let's just say you bought that stock for $100, okay? And let's say it vests, we'll talk about this later, but let's say 50% of it's vested. By the time you go, I'm out of this corporation, I'm leaving. We're gonna buy your stock back, the half that has invested, for $50. even though you've put a lot of time and effort into the company and it's worth a lot more, I'm taking your stock back as the corporate counsel for $50. Because the investor's not putting their money in to see you lead, to walk off, to take that maybe a $50 investment and use their investment money and just walk away from my company, because they gotta replace you.
Is that a time limit though? Like so many years?
Yeah, I mean, there's some standards for this. We usually do a 4-year vest, and we'll get to that in a moment, so
Alright.
give me just a moment, we'll be at that in a moment, so. A lot of stuff. We're gonna get to that all in a moment. We've actually already talked a bunch about trademarks, but you ought to do some research before deciding on a name. Really do the research and see if your name that you're gonna market on is out there. It's pretty easy to at least have some idea about it. Fill out the business description, the corporation questionnaire, and tell us kind of what you're doing. So if I see that you're gonna use the name Coke in connection with a beverage, I'm gonna be like all on you, right? But if you use the word Coke, that's a famous brand, I shouldn't use that term, because actually a famous brand can get you anyway. But if it's about a table, I'm not gonna be as concerned. A Coke table, a Coke carpet. With Coke I would, because it's a famous brand and they can still probably sue you. But for these kinds of searches, if you wanna get kind of a quickie search from us to kind of get an idea, it costs about $500 to do that kind of search. If you want to get an in-depth search, we use outside vendors to do that, and it costs somewhere between $500 and $1,300. That is the cost to pay the outside vendor to do these complete searches. And these searches can come back with hundreds of pages depending on the name and the logo. And then you need a lawyer to actually analyze it, look at some of the big heads and tails of what this thing is. So hopefully we're trying to clear the name for you. Trademark applications all in are usually $2,500 or so. It can run up to $35, but usually, maybe we can do it for less. It depends on what it is. Is it one class? Is it 2 classes? How broad is the description? How complicated is what you're trying to do? Is there a logo involved? Is there not a logo involved? Are you trying to do it internationally or not? We have to talk to you kind of about what your strategy is about that, because it can get complicated. But that kind of just gives you an idea. But definitely look at the name before you go, if you're going to use the name of your company to brand your products and services. You don't necessarily have to, right? So you can call it ABC Corp, and then Coca-Cola is the brand. Again, I'm sorry to pick on Coke, but you know what I mean. So.
For trademarks, when you submit an application, I heard that there's a possibility that you make your payments and they do all the searches and they come back, they can say, hey, we don't approve, and I need your money back.
So this is the reason why you don't want to do what's called, we call it a blind application. Some entrepreneurs will, why don't I just file it and see what happens? That's because one of 2 things can happen. Either the examiner at the Patent and Trademark Office looks at it and goes, well, wait a minute, you're gonna try to mark the Coca-Cola name. There's a name out there called Coca-Cola. No. Or Coke comes along and opposes your mark. They see it published. Companies have policing, companies they hire, particularly if they're well known, that actually spend time policing these marks. Same thing for copyrights. That picture I told you guys about, they wanted to sue my poor little client because someone posted, someone searches their people, that's all they do. They go online and they're seeing how people use names and marks and logos and so forth. So I know this stuff sounds expensive. I mean, I get it, I totally get it. But if you're really gonna invest a lot of money in scaling your business with this great name, make sure no one else is out there using it, or we can kind of clear the mark. That's why you're spending this money, by the way, because we're spending this money to clear the mark so that when you file the application, you spent your money on me and you spent money on the filing fees, which are I think they're about $275 a class, depending on what the service what you're describing. We're pretty sure that we can get it through. Yeah.
It's like you're paying for the due diligence.
You're paying for your due diligence, right? Why waste your money if you don't know you can get it? And also, you spend all this time, you're out there doing stuff. People know your brand, you're building up, and then all of a sudden, and by the way, it takes about 6 months to hear from the trademark examiner. Meanwhile, you're doing your business, you're using the Coca-Cola name, you love it, it's going really well. All of a sudden, and to get the actual mark approved, it often takes up to a year. So that's why we want to do the investment early, because it's not just, oh, I'll hear about it in a week and then I can change my mind. You've put all this time into all your marketing and the name of your product and you're in it. Yeah.
So on the point about naming your product something different from your corporate entity, is that considered as like DBA, or is that only if you're like using a different name for your actual company?
Yeah, that's the legal name of your company. You can decide to do that. A lot of companies, right, they'll call it, I'm gonna make it really generic, ABC Corp. And then I've got this beverage called this, and I've got this, cereal called that. So General Mills, right, has Cap'n Crunch and whatever they do. General Mills is the name of the company, but they don't market their cereal under that name. They're just the legal entity. So that's another strategy to consider if you're gonna do multiple products that you wanna brand differently. You could call your company one thing and then have, this product, this service, et cetera, and that's often a strategy for how to build a company and potentially build a brand with value, because later on you want to think, okay, what am I going to do with these lines of businesses? Maybe what you do is you build the lineup over here with the name of the brand and you sell it, but you still have your company name. You can still keep your company name. So that's some strategies we can go into depending on what you're trying to do and how you're trying to exit. So how we kind of try to figure out your intellectual property portfolio, we call it, right, of patents, trademarks, and how to monetize it.
These trademark searches that you're discussing here, are these domestic or international?
They're domestic, and then if you're thinking about doing something international, then we kind of have to think about it a little bit more. There's treaties that allow you to go. If you can qualify for a mark in the United States, it allows you to qualify for the mark easier in other jurisdictions under what's called the Madrid Protocol, but you still have to worry about it on a country by country basis. There's some strategies with that, but these are for an initial trademark.
And I think every country has their own DEs.
They do, and so, like for instance, we represent Blue Cross Blue Shield. Everybody knows that, right? We represent them in 70 countries. Because they have to police their mark in 70 countries. We work with affiliated law firms all over the world to do it, because each country does have their laws. Now, the fact that, and we didn't represent them at the beginning because they probably started like 100 years ago or whatever, but they have a base trademark. We got the trademark in the United States, and they use the right of the trademark in the United States, or this is what you might do. And I'm actually working on this right now for an Indian company that has a mark in the United States, and is trying to figure out, okay, where else am I doing business? In the EU? Should we go to the EU and try to get an EU mark? Are we going to go to China? And then you have to really think about the country and whether they respect intellectual property rights. How can you maximize your budget for going wherever you need to go? And you have to kind of prioritize to probably start. But yeah, it's an important point.
So if you started in the US, but you have something that's like an app, and it's available in Canada through the same app store or through a different version of the app store, I don't know if treaties cover that, or if you have to get a trademark in both countries.
You do.
Yeah.
You're not covered by a U.S. treaty in Canada. But again, there's these treaties that allow you to piggyback off the rights in the United States that make it simpler and a little less expensive. But we have to go to Canada. We have to figure out whether anybody could potentially block it. It cuts the attorney's fees down in the other jurisdictions, though, because there's sort of a presumption that, okay, I have this U.S. market, there's nobody blocking it. So, okay, I'm going back to Coke, I'm sorry. So I got Coca-Cola on it here. I'm going to go to Canada. Does anybody have a Coca-Cola mark? No. Good. I can use my mark to kind of get a quick approval in Canada as long as there's not a blocker. So what that means is there's a filing fee. There probably would be a filing fee, but the attorney's fees, that's the biggie. Really less on the attorney's fees and the search fees. So it's a way to kind of piggyback on your rights in the United States. So you start with the U.S. because you're here, and then we try to figure out, okay, where are you really going to be? EU is a really big market. Let's go to the EU. Should I just register in France? No, because we're going to do the whole EU. So let's do the whole EU mark at one, Or are we going to go to China? Everybody wants to do China. Okay, are we really going to market there? You have to really think about your strategy in China, because it's a pretty, it's a pretty unique place. It's a dynamic place, but it's also, for instance, you have to be careful with your IP.
Is it possible to change your company name after registering it, or you have to stop it and register another? So
No, you can amend your articles to change your company name anytime you want, as long as it's not a name that's taken.
Okay.
So I've got this, actually that Indian company I just mentioned to you, they're known as a certain name and they file a DBA to be known as something else. The something else is actually how they brand their products and service, but it's just causing them craziness because there's a Delaware company by the name of the DBA that they're using to market their software. There's also a California corporation. And so they're trying to figure out what do we do, and I'm telling them there's nothing you can do. You cannot go get that name. You have to buy the name. You have to go to this little dinky company called whatever they're called, and you have to say to them, could you change your name for me? Because I really like that name, and they'll charge, and then you're
Negotiating.
You're negotiating, yeah. I also did this actually with a trademark once with, I think they have the Fairmont down here. Don't they have the Fairmont down here yet? So Fairmont started in San Francisco, very famous, Fairmont Hotel. If you guys are, huh?
Yeah.
Yeah, they're Beverly. Now they're owned by a Canadian company, by the way.
Yeah.
We sold them actually, this big Canadian conglomerate. But when I was a young lawyer, they were just in San Francisco and a couple of Northern California places before they sold to this Canadian company. So Fairmont, right? But they, it's public knowledge. Yeah, it's public because it's on the trip patent. I can tell you this. So they have a mark, but there was a little hotel called the Fairmont in Miami Beach, and it had been there a long time. And remember I talked to you about police earmark? Well, they just overlooked that this little Fairmont in Miami. How many people in Miami Beach, right? Those little cool little hotels on the beach. Well, one of these was named the Fairmont. It had been around, since the 50s, and they had their little neon sign. And all of a sudden, the Fairmont got wind of it, right? And they're like, wait a minute, we overlooked this. So I had to go down there and negotiate to change their name. We had to pay this little dinky hotel a little bit of money. Now, Fairmont was a pretty big company by that time, and this hotel didn't want a lot of trouble, so we paid them to change one letter, and we paid for the neon sign. I forgot I think we changed it to Fair Wind or something like that. But this is the point. You have to police your mark, and by the way, if they hadn't done that, it creates problems for the company, because then people come along and say they didn't police your mark, and you lose rights if you don't. It's deemed to be potentially abandoned. So, God forbid if you're a big company like that. But even if you're small, you got to put time thinking about your name. If you're going to start scaling it and spending all your time and money on that, you kind of try to figure it out front if it's going to be a problem. So, anyway, that was kind of fun. I didn't get to go to Miami Beach, though. I had to go on the phone. But it was kind of fun for me. I was like, hey, we're going to change the letter. That's kind of cool. Then we had to get all this artwork. We had to work with it. We paid for their sign, get a neon sign guy to go in there and do it. It was kind of cool. So, now they've been bought by this Canadian conglomerate now, and Fairmont's everywhere. So not quite the same company it was, but okay. So all right, now we're going to talk about stock a little bit more and what we recommend, and a little bit about this vesting thing. So
Can we take a short bathroom break?
yeah. You want a bathroom break? Sure.
Yes.
Yeah. Okay. Sorry, I talk a lot too.
That's
so
okay.
I hope it's not boring. If you're bored, tell me you're bored.
It's been a
real honor.
Yeah. One conversation we had or something.
They cannot be your competitor.
And we pick the worst one.
They can't compete.
I know, that's why it's moving
In California?
I don't know. I'm just asking.
Yeah.
Can they compete against since they
As long as they're not taking a trade secret in California, then you can't stop an employee from taking their knowledge and starting a competitive. As long as they're not taking trade secret. If they're taking trade secret, that's why you want them to sign that thing. To say you're signing all the IP to me and you won't take my trade secrets. So.
Some wine here. It's on the
I felt like it's not square.
Oh, I had to.
That's the cost of
I know, I had to take my P&L and copy and paste it.
But then what was the problem was that, I had to readjust over 5 years all my expenses. Because just because I started $100 year one,
It's not bad.
let's say month 12, and I
It's,
hired like, 200 people, there's no way to spend that.
I love Chardonnay. It's okay. It's wine. Yeah.
The,
A little bit warm,
on the executive, summary, it asks you for everything.
Bud Light.
It says operating
To
income.
5 years?
4 years, it's 4 years.
Oh, I must have deleted the other ones, cause I only put for 2 years. So I put for physical.
Used to work for Miller.
It's 4 years on the exam.
Okay, yeah, I deleted, I had,
Well, I didn't do it for 5 years, for 4 years.
Yeah.
And
It's okay, but it's like, startups, like, 2 years, you go past 2 years, you didn't start, you started from also
I guess y'all just hang in here.
Hi.
Whoa.
Just public information.
Yeah.
My brain started. Yeah, I'm gonna probably have to like spend 3 weeks on this slide by itself.
You guys all got incorporated?
Now I'm just like, oh god, I need to stop and read everything, like, what if I don't have this, oh my god.
This is a pretty big deal though, like,
Yeah, it's a
I've
very
paid,
big deal.
I paid like 7,000 to 8,000, I didn't get all of that.
That's,
So I wish I would have paid this.
2,500 too.
Yeah.
So it probably costs about 3,500, not including trademark.
most of this for like 1,200 with Gus launch. A corporation, that's also how I have,
You got all this done for 12?
yeah, a lawyer, like I get a free hour every month and I never had to pay them a retainer.
That's good deal.
Yeah.
you're kind of based on you.
So, and they like,
Remember we talked about that?
Do they scale with you or they just help you
yeah,
incorporate
no,
it?
like you can, they scale with you, like as you go, like you can provide revenue packages to get like, so kind of the CFO, like provide shit built in.
Oh God.
They have like good
You want some?
connections.
Yes.
So they like make your profile and
send it to
push
you.
it out to investors and stuff. And there's like different options. To like look into them. You want 15% off.
Everything. That's all right. No.
I did a joke.
Oh, there they go.
It's never a problem to make a law firm give you.
No, at least it looks like I didn't drink the whole bottle. Cheers.
So it's Gus that gave me like an affiliate code of like, you know, like need to incorporate your like multi-services, so like they work with like a shit ton of law firms, so they just list it and like a lot of them get paid from them. That's how I ended up with the 3 hour, but like if I go over my hour, like I pay.
$400.
Yeah.
It's crazy. I'm in contact with different law firms. They're like different levels of people. The cheapest person is $395 an hour.
Yeah.
The most expensive person is $800 an hour.
Crazy.
So it's like,
I wish I could bill $800 an hour.
it's like different people doing different things, right? Or do you just?
Different
go
levels
one
of what
way?
you want. Sorry. Like if you want to work with the boss, and have the boss doing your stuff for you, it's $800 an hour. If you want somebody who's been there for like 5-6 years, still got experience, knows what they're doing, but doesn't have a name for themselves yet, it's gonna be a third of the price.
Like over mine?
I need dinner. I'm starving.
I had a question for you actually. Yeah. So, first of all, whenever I tell you
I think I'm gonna drink this out of mine, I can't like.
Whether you ever hire me as a lawyer or not, we have a attorney-client relationship privilege and nothing that can.
Everyone else is like,
right now there's about
please calm down, like half a year.
stockport websites.
Oh, okay.
I was worried about drinking too much because I like it affected me with no food.
Oh, yeah,
She's
yeah.
like, hey, you got a pitch. Oh, great, okay.
The name I chose was typing. Because you're typing it.
I don't think so. She didn't make us do in the beginning.
Yeah, I see it was taken by
And I was like, wait, what?
On the like spectrum, you know?
Yeah.
There's one company on the East Coast, it's an Italian restaurant with the same name. But it's a restaurant. Do I need to worry about anything?
Two?
Trademark rights like this is on market course. You would market.
No, this is from,
Oh, not?
it's free.
So
it's just got like a sweatsuit that's got silver stripe.
Yeah.
But it's like a sea foam green. There's only certain Michael Kors stores that carry men's.
Yeah.
So they don't even wait for me to show up at the store anymore. They call me or they text me. We just got this in. He sends me a picture. He's like, "Do you want me to send it to you?" So they just want to make their numbers. It's crazy. It's like, I found these shoes in your size. I'm going to send them to you. I already have your credit card. I'm like, wait a minute. I have to agree to this first.
And then like, no, trust me, you'll love it.
Yeah. You're like, okay, but if I don't want it, it's coming back to you.
Probably, okay. But you should still get a training registration. And so even if you don't have your name, if you don't, people can geographically use the name and you also get graded rights.
They do?
Or people if you're on
So, as far as B Corp, does it have to be something tangible like environmental or habitat like humanity, or can it be something social like we're doing grief support app development?
Group support.
Grief support. Yeah, for grief support for grief support.
Yeah. Sure.
So that's
so it's a service company, a company that helps people provide them support.
Right.
Yeah,
It helps them connect with each other, but also there would be a professional component on the back end, so that their services are available to clients through the app.
Yeah.
Sure, that's probably ideal. Everybody was pointing at me when they heard you say it. What?
All sorts of these companies have used this because they're trying to take care of all their stakeholders. Patagonia, right? They're trying to take care of their products or service. It doesn't have the environment, even though you go hiking, you go farming, whatever. That's a famous brand that does it well. So I think almost any company can do it as long as you're really trying to take care of all your stakeholders and not just maximizing wealth for their stockholders. Important.
That was my whole concern, we were waffling about this whole LAFI thing and the possibility to have a profit. There's all this back and forth about it. This is the first time I've heard about it. So that gives us an option.
Oh, yeah. I've done a lot of them. And B Corp doesn't mean no profit or lower profit. Actually, costly. If you have a better run company that takes care of your employees and the environment, you're actually reducing your risk. You're creating a premium product or service. You're going to have better employee engagement, which is going to make higher retention, which is going to reduce your employee turnover costs. You're going to make more money. B Corp will actually come out with a study based on these companies and making us it's a 10% kicker on top of companies that are if you're doing it the right way.
And is there an actual definition of you taking care of the reviews in that B Corp? Or
Yeah, but, I mean, so you can set the specific public benefit that you want to create. It can be everything from, creating this product reviewing more environmentally sensitive way.
You said that I started recording with my phone because I didn't see
As long as you're trying to create a
I'm glad.
some money to do other things.
Because sometimes I do
10% of my money
kind of
saved.
slip.
I didn't see it because I was over here on the other side of this pillar.
Right? That's